Hi everyone, I'm Raj Sharma, managing partner at Stewart Sharma Harshani, one of Western Canada's largest immigration law firms, and I thought it would be a good idea to provide everyone with a synopsis of the upcoming changes to Canada's citizenship laws. As of right now, we are dealing with or subject to Bill C-24, which became law some time ago. And that law was called Strengthening Canadian Citizenship, which ironically means making citizenship harder to get and easier to lose. So as of right now, in terms of language proficiency, applicants for Canadian citizenship need to show language proficiency, usually by way of a test, and that requirement is imposed on anyone between 15 and 64 years of age. Bill C-6, which is at the Senate, the Liberals or the governing party proposed age where we have to demonstrate language proficiency between 18 and 54. Now, the Senate sent it back, and they proposed 18 to 60. So that 18 to 60 or 18 to 54, that's probably what we're looking at. And again, this law is probably going to be enforced perhaps sometime later this year. I think this is generally a good thing. I think that the requirement to have a 14-year-old or a 15-year-old or a 16-year-old provide language proficiency examination or prove language proficiency was a little bit foolish. I mean, if you've got a kid who's 14 or 15 years old, they've already been in Canada presumably for a minimum of 4 years, and having them provide a language test seemed to be an unnecessary hurdle. So this is certainly something that I think a lot of individuals will welcome. The residency changes is what's significant in my view. The current regime is 4 years out of 6, and out of those 4 years you need to be in Canada 2 feet on the ground, minimum 183 days per each of those years. Plus you have to indicate an intention to remain or reside in Canada, which I think is somewhat strange in this globalized economy. The reset button has been pressed here. Liberals now want 3 years out of 5, or 1,095 days, which is basically what it was before the Conservative changes. There is no intention to reside or a requirement to indicate that there's an intention to reside under Bill C-6. I think what's really important here is that the Conservatives, Bill C-24, the Conservative citizenship regime, didn't count any days prior to someone becoming a permanent resident. So, for example, you're here as a student or a worker, you're a protected person. For whatever reason, the Conservatives saw fit not to count any of those days in favor or towards the citizenship requirement. I think that was foolish. And under the new regime, or the new proposed regime, the Liberals will count a certain portion of those days, and I think that that's a good idea. In terms of citizenship revocation, obviously Bill C-24, this is what hit the headlines. They allowed revocation of citizenship for dual nationals that on grounds of national security. So individuals that were convicted of terrorism or espionage or fighting against our armed forces. That is now gone. Of course, the Liberals are saying a Canadian is a Canadian is a Canadian. That might be politics from both sides. I'm not sure. Not a lot of individuals were affected by this, but it did seem to play a role in the Conservative election loss. In terms of revocation for fraud, the Conservatives now revocation for fraud has always been with us since 1947. So most of this is individuals misstating or overstating their time in Canada. That is still possible. The Senate has saw fit to reinstate an ability to access review before the federal court. I'm not sure about the sort of practical repercussions of this. I mean, most individuals that said that they were in Canada and they're not in Canada, they're actually outside of Canada, and very few of those individuals actually sought federal court review once Canadian authorities found out about their deception. So I don't think this is a huge issue, but due process is something that should be generally welcomed. Finally, I think there's a small amendment here which the Senate proposed, and it wasn't in the Liberals' bill that they sent up to the Senate, which is that up to now, kids were kind of lumped in with their parents. So if you've got an individual who's 14, 15, 16, 17 years old, they can't apply for citizenship on their own. They've got to apply with a parent. You might have a situation where a parent is not in compliance with the residency requirement in terms of citizenship. They're meeting the residency requirement in terms of maintaining their permanent residency, which is a whole different calculation. The kid might make it, but the kid can't apply for citizenship until they're 18. The Senate proposal will allow children to apply on their own merits, and I think that that's a good idea. I don't think we need to have kids and parents in terms of a package deal. I'm sure an individual 16, 17 years old can certainly apply and sign off on their own citizenship application, provided that they comply with their residency requirement. So that's it for my summary of the proposed changes. This is likely what's going to be law later this year. And for this and any other immigration or refugee or citizenship related question, please don't hesitate to contact our office, Stuart Sharma Shani, at 403-705-3398, or on the web, of course, at sshlaw.ca. Thanks.